Hi, welcome to New Start's Immigration International channel. Today we are going to provide you extensive understanding of the Australian partner visas. New Start has over 15 years experience in the immigration industry. New Start is made up of a team of more than 20 migration agents and immigration lawyers who all share the same passion and knowledge for helping people like you to migrate to Australia. I'm Jack, who is a registered migration agent and also a lawyer admitted in the Supreme Court of New South Wales. In 2021 fiscal year, Australian government had allocated a large quota for partner visas. This is a great opportunity for those who are planning to move to Australia with their significant partners or spouses to start acting now. I will talk about the general requirements for the applicants and the sponsors, and talk about the supporting evidence you need to provide to the Department of Home Affairs. And also we will touch some about the upcoming changes. Alright, let's look at the types of partner visas. There are three types of partner visas to Australia. First, the prospective marriage visa, subclass 300. Number two, offshore partner visa, 309-100. And onshore partner visas, 820 and 801. The basic requirement is that both partner visas assume that your relationship with your partner is official, that is, you're married, no matter in which country, or that you are de facto relationship, which is officially registered. The only difference between the offshore and onshore partner visa is where you apply for the visas. So subclass 309-100 is applied for from outside Australia, and the waiting for the visa decision takes place outside Australia. And A20 and A01 is filed in Australia and with the bridging visa generated upon lodgement, which gives you the right to remain on the country while waiting for the decision on your partner visa. Prospective marriage visa subclass 300 is for those who are planning or just planning to officially get married. The prospective marriage visa is a temporary visa valid for 9 months, during which time you must formalize your relationship and then apply for a partner visa in Australia. So because you will be applying from within Australia, the partner visa you will be applying for subsequently is A20 and A01. When you apply for partner visa, whether inside or outside Australia, you are submitting two applications at one time. For the temporary visa, which is A20 or 309, and the subsequent permanent visa, which is A01 or 100. After applying for the temporary visa, a 2-year waiting period begins. After 2 years, you can then apply for permanent residence visas. There is no additional fee at this stage, but you do need to provide additional information to the department of confirming the integrity and the longevity of your relationship. Alright, let's talk about the cost of applying for the partner visa. The cost for the primary applicant is 7,715 Australian dollars, while if it is a 300 visa, then on top of that you will pay a fee of 1,285 for your subsequent partner visa. So within the 9 months after you get married, you can then apply for your partner visa, and then you will need to pay that additional fees. Besides, an additional application fee is also payable for each family member who applies for the visa with you, and this is mostly are your children. If you have children from previous marriage and who are not Australian citizens or permanent residents, you can make a combined application with them. I want to draw attention that it is very important in the case of a visa refusal, those costs are not refunded, and we are talking about roughly $10,000 after you take into account your translation of the documents and so forth. Therefore, it's very important to prepare your documents in such ways to minimize the possibility of visa refusal. Unfortunately, the sincerity of your relationship is not always a guarantee of a successful application. The department views each claim with the presumption of guilty, so to speak, that is from the position that you are trying to deceive the department, and it is your job and duty to prove them wrong. Therefore, it's best to engage an experienced migration agent or immigration lawyer who will help you prepare a complete and rigorous document for your submissions. Alright, next part, let's talk about the validity of a visa application for the partner visa. In most circumstances, you may lodge a valid application for the offshore partner visa. However, if you are applying for onshore partner visa, the application is not always valid. I will talk about several different scenarios to make a valid partner visa onshore. So scenario 1, the applicant has a substantive visa without no further state condition on that visa. So to be eligible to make a valid partner visa application, the applicant needs to meet one of the following criteria. You and your sponsor have been legally married in a country, or you have been in a de facto relationship for at least 12 months. Or the 12 months requirement can be waived by registering your relationship in an Australian state or territory. The number one criteria is self-explained. I want to explain more about item 2 and 3. For example, if you and your sponsor only have been living together for, say, 5 months, but your current visa will expire soon, and you want to apply for the partner visa onshore in Australia before your current visa expires. In this case, you may still be eligible to make a valid application if you register your relationship in a state or territory which has a registration service. Alright, scenario 2. The applicant does not have substantive visa and has a visa refusal decision since last entry to Australia. We usually call this situation that the applicant is barred by Section 48 of the Migration Act. To make a valid application for a partner visa when the applicant is Section 48 barred, at the time of application, the applicant needs to provide at least 2 statutory declarations by 2 supporting witnesses who are Australian citizens or permanent residents. The statutory declaration is in Form 888, which can be usually provided to the department during the visa processing time. However, if the applicant is Section 48 barred, these declarations must be provided at the time of application to make this application valid. Next part, let's talk about the limitation of the sponsorship. The limitation on the partner visa sponsorship is essentially to prevent a person from sponsoring multiple partners. If you have sponsored a person in the past for a partner visa, you would have to wait 5 years before you can sponsor another one. However, the maximum number a person can sponsor in a lifetime is 2 people. The question is, what is counted as sponsoring a person? I will go through some examples here. Number 1, if the visa was granted, but the applicant did not travel to Australia. This is still counted. You have essentially sponsored a person, and it doesn't matter that the applicant did not travel to Australia. Number 2, if the prospective marriage visa was granted, but the wedding did not take place. Unfortunately, it still counts as using up one of the sponsorships. Generally speaking, if the partner visa is granted, it will be counted. If the partner visa is refused or withdrawn, it will not be counted. The limitation can be waived if compelling circumstances are affecting the sponsor. Compelling circumstances include the applicant and their sponsor have a dependent child who is dependent on each of them, or the death of the previous partner, or the previous partner abandoned the sponsor and there are children dependent on the sponsor requiring care and support, or the new relationship is long-standing. The Immigration Department will look into the following criteria when considering whether compelling circumstances exist. First, the nature of the hardship that would be suffered by the sponsor if the sponsorship were not approved. Second, the extent and the importance of the ties the sponsor has to be in Australia, and the consequent hardship that would be suffered if the sponsorship were not approved. And the sponsor were to feel compelled to leave Australia to maintain their relationship with the applicant. Let's move to our last section here, the relationship evidence. There are 4 different categories for the relationship evidence that you need to provide to the Immigration Department, including financial, household, social, and commitment documents. So for the financial documents, these documents may include 1. Joint ownership of real estate or other major assets such as cars, shares, etc. 2. Evidence of joint liabilities such as loans, mortgages, insurance. 3. Joint bank account statement. And 4. Shared household bills and other documents showing shared expenses. Number 5, superannuation beneficiary. Okay, for the household documents, these may include 1. Joint tenancy or home ownership. These are documents for the residence in which you live together. 2. Joint utility accounts, for example, gas, phone, electricity, internet, these kind of utility bills. Number 3. Other correspondence addressed to you and your spouse at the same address. For example, letters or cards sent by your friends, family members, or parcels. 4. Written statement describing your living arrangements and how you distribute responsibility for housework. Alright, documents for social documents. 1. Evidence that you and your spouse are accepted as a couple socially. For example, joint invitations to social events, photos taken during social outings, photos taken during social outings, and your social media profiles. Number 2, documents showing that you have traveled together or have booked future travel together. For instance, joint travel itineraries, tax invoices for flights, boarding cards, accommodation bookings, and travel insurance. The final part of the documents need to be provided to the immigration department is the level of commitment documents. Correspondence, letters, cards, emails, texts, and itemized phone accounts showing that you and your spouse maintained close contact during any periods of separation. Number 2, any document showing how long you have been in a relationship and how long you have lived together. Number 3, you and your spouse or partner's wills to show your commitment to each other. And 4, a written statement in a form of statutory declaration about how your relationship developed and your future plan. The above list is not exhaustive. Any documents that clearly show that your relationship is genuine and continuing should be provided to the immigration department. Alright, that's all about today's video. If you like our video, please remember to subscribe and hit the bells. And we'll continue put on more interesting information in the future. Thank you. Bye.